This is your ARC. Y'all is magnified. Coming back with another informative video. I titled this video, The Difference in Response. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, let's get to it. Okay, guys, so as you all know, uh, I've been doing videos back to back to show you all the responses that other people get on YouTube, right? When they send their clients into the court. So when we read those responses are filled with what? Case law and legal authority to support their argument, right? So now we're going to see the response my aunt get when we file documents into the court, okay? So now, as you all can see, this is from my aunt Seth. If you go back to that video that I just put up like a few days ago that was titled "Arrears Went Bye-Bye," that was his um email, and that was his document showing that the arrears is now zero, okay? But as you all can see on the screen, they petitioned the court back in March 5th, 2020, right? So, let's read it. It states, motion to reduce child support arrears to judgment. Comes now, the respondent. And that's his child's mom name. We crossed it out. By and through her attorney with the attorney name. Then it says, and makes application to this court to reduce the child support arrears to judgment in favor of respondent. With his child's mom name again. Then it says, in support hereof, respondent, his child's mom, alleges and states as follows. So now we can see they have my arc as the petitioner, but he's not the petitioner. They are the petitioners. That loud motorcycle go past. But they are the petitioners. Okay, as we just read, it's their motion. They're moving the court. The only reason why my arc is the petitioner because he had an attorney before me, so my arc actually moved the court. But then he fired his attorney, but they're still holding him as the petitioner. Okay, so now let's go to the next motion they filed, all on the same day, all on March 5th, 2020. As you can see, this one now is a what? Respondent motion to modify temporary order agreement, amend request from joint custody to sole custody, and to modify visitation. So now you all can see it's the same one, March 5th, 2020, same date. Still my accept. This is everything he's going through, right? Let's read it. Comes now the respondent, the child's mom again, and for respondent's motion to modify temporary order agreement, amend request from joint custody to sole custody, and to modify visitations. Then it says shows the courts as follows. So again, they wrote all this up. We responded back to both. Okay? So now we're going to see their response. After we responded back to both of these, we're going to see their response to our response. Now let's see how they respond back to when we file our documents into the court. Okay, as you can see, their response was what? March 18th, 2020. Now let's read their response to our response. Because we sent what? It says respondent, which is them. They are answering to what? The petitioner motion to dismiss, respondent motion to modify temporary order agreement, amended request for joint custody, to sole custody, to modify visitation, motion to reduce child support arrears to judgment, and to move to terminate support order. Okay, so we did what? We filed a motion to dismiss all their complaints, and we moved to what? Terminate the support order. So now let's read their response in its entirety. It says, comes now the respondent, his child's mom name, by and through her attorney, with their attorney name again, and for respondent's answer to petitions, motion to dismiss and terminate support order, dated March 10th, 2020, alleges and states as follows. So again, my arc, I gave him a motion to dismiss and a motion to terminate support. Okay, so we did what? We moved to dismiss everything that they claimed, and we moved to terminate the support order. But let's continue. It states, one, that the respondent slash defendant denies each and every allegation contained in the first paragraph on page 1 of 7 of petitioner's motion to dismiss and terminate support and demand strict proof thereof. Let's go to paragraph 2. That respondent slash defendant denies each and every allegation contained in the second paragraph on page 1 of 7 of petitioner's motion to dismiss and terminate support and demand strict proof thereof. Let's go to paragraph number 3. It's all starting the same, right, guys? Let's continue. That respondent slash defendant denies each and every allegation contained in paragraph number 1 of the petition's motion to dismiss and terminate support and demands strict proof thereof. The acknowledgement of paternity signed by petitioner/plaintiff is attached here too and marked as exhibit. We already handled that as well, but let's continue. Number 4, that the respondent/defendant denies each and every allegation contained in paragraph number 2 of the petition of motion to dismiss and termination of support and demand strict proof thereof. 5, that the respondent/defendant denies each and every allegation contained in paragraph number 3 of the petition, motion to dismiss and termination of support, and demand strict proof thereof. Number 6, that the respondent/defendant denies each and every allegation contained in paragraph number 4 of the petitioner's motion to dismiss and termination of support, and demand strict proof thereof. Number 5, that the respondent/petitioner denies each and every allegation contained in paragraph number 5 of the petitioner/respondent motion to dismiss and to terminate support and demand strict proof thereof. Number 8, that the respondent/defendant denies each and every allegation contained in paragraph number 6 of the petition of motion to dismiss and terminate support and demand strict proof thereof. But as you all can see, we don't get anything but demand strict proof thereof. You see? But let's continue. Let's continue to the rest of the numbers. We left off at 8. Let's read number 9. Number 9, that the respondent/petitioner denies each and every allegation contained in paragraph number 7 of the petition of motion to dismiss and terminate support and demand strict proof thereof. That the respondent, number 10, that the respondent/defendant denies each and every allegation contained in paragraph number 8 of the petitioner's motion to dismiss and terminate support and demand strict proof thereof. Number 11, that the respondent/defendant denies each and every allegation contained in paragraph number 9 of the petitioner's motion to dismiss and terminate support and demand strict proof thereof. Number 12, that the respondent/defendant omits in part the allegations contained in paragraph number 10 of the petitioner's motion to dismiss and terminate support, and that this court held Seth, that's his whole full name, as the obligor, and further ordered that the plaintiff pay $718 per month child support monthly. The respondent/defendant denies each and every other allegation contained in paragraph number 10 and demand strict proof thereof. Number 13, that the respondent/defendant denies each and every allegation contained in paragraph number 11 of the petition motion to dismiss and terminate support and demand strict proof thereof. Then it says, number 14, that the respondent/defendant denies each and every allegation contained in paragraph number 12 of the petition motion to dismiss and terminate support and demand strict proof thereof. Wherefore, having fully answered the petition motion to dismiss and terminate support, the respondent prays that the petitioner motion be wholly denied, that the respondent be granted her reasonable and necessary attorney fees and such other further relief this court deems just as equitable. But as you all can see, with the attorney signature, but as you all can see, he didn't file any rebuttals. Not one rebuttal. You see? He simply denied. Why? Because he can't rebut what I put on there. Why? Because we have legal authority to support everything that we're saying. That's the difference. Nowhere on these documents do it say failure to state a claim upon which relief can be granted. Okay? And there's no legal authority to even try to deny what we filed. As you all can see. No legal authority on this document at all. They quoted the same thing 14 times. That's the difference between the responses, guys. So that's what I tell you. When somebody know what they're doing and they know how to respond, they know how to write legal documents up, this is the type of reply they get. Only those who do not know how to write and who do not have understanding of what they're doing will get failure to state a claim, and they will get a 16-page rebuttal or a 22-page rebuttal. Okay? They didn't rebut anything. They simply denied without providing evidence of why they denied it. Okay? You can't deny the fact if you're bringing a case against him. They're bringing the case against him, but now they on defense talking about they deny everything, and now they want him to show strict proof. How can he show strict proof of something that you're bringing to him? It just don't make sense, guys. That's the difference, and that's what I want to show you all. Learn, understand. Power is in knowledge, man. I cannot stress this enough. And for people that's saying that I'm wishing bad on Gary Lynn, I was never wishing bad on Gary Lynn. I was just telling the truth about the situation. The truth may sound like hate to those that hate the truth. The court does not have jurisdiction, and it's just that simple. I know these things. Why? Because I study. I read. That's why I think we get responses like this. You see? This the only thing that the attorney can write. After the attorney petition the court, the attorney turns around and goes on defense when we filed our response to their motion. That's what you call, and that's how you know who know what they're doing and who don't. We switched the whole thing. Now they're running, trying to say they need strict proof from us to prove what they're trying to prove against us. No, we're not going to prove nothing for you. You hear me? And it's just that simple. So again, guys, that's all I'm going to do for today. This is the difference in response. So if you all need my help, hit me up in my email at yahismagnified@gmail.com. Let's get this right wisdom, this right knowledge, this right understanding. More powerful videos coming, more testimonies coming. Come on, man. Be moving in 2020. 2020 is going to be a powerful year, guys. So again, with that being said, I say shalom.